Hello and good morning, everyone. My name is Jillian Bender-Cormier. I'm brand manager with Bender Insurance Solutions. We want to welcome you to another educational Bender U webinar covering construction and employment law updates for 2021. Some housekeeping notes. At the end of this webinar, we will have an engaging Q&A session that I will be facilitating. Our speakers are also available to answer any questions that arise throughout our presentation today. If you have any questions during the webinar, please feel free to type them into the chat box or in the Q&A section. During our Q&A time near the end of the presentation, I will be sharing additional questions with our speakers. We want to be conscious of time, so if we don't get to answer all of your questions, we will gladly reach out to you individually after the webinar. You are all in listen-only mode and will remain muted throughout the webinar. This session is being recorded, and at the conclusion of the webinar, the recording link and slide deck will be forwarded to you. We have a fantastic set of experts sharing with us this morning, but I'll let Bender's own VP of Construction Risk, Edward Johnson, do the honors of introducing them. Welcome, Edward.
Thank you, Jillian, and good morning, everyone. Happy Groundhog Day. Just in case anyone's been on pins and needles, Punxsutawney Phil did come out today, and he did see his shadow. So 6 more weeks of, as I'm looking out the window, rain and snow in the mountains, hopefully. I'd like to take this opportunity to introduce our first set of speakers this morning, Mr. Scott Alexander and Mr. Kenneth Schumacher. Scott Alexander currently serves as the managing partner of Murphy Austin Adams. Scott practices business and commercial litigation throughout all California state and federal courts, with a primary emphasis in construction and real estate litigation, public contracts, and complex contract disputes. In addition to his litigation practice, Scott has significant experience drafting and negotiating all types of public-private project construction contracts, including design build and energy service performance contracts and related construction documentation across various construction project delivery systems. Scott received his JD with distinction from the University of Pacific McGeorge School of Law in 1997. Prior to receiving his law degree, Scott facilitated municipal finance transactions and drafted related legislation for the California Housing Finance Agency. Thank you for joining us, Scott. Imagine thunderous applause is happening throughout the region on the internet. Now, you're welcome, Scott. And Mr. Kenneth Schumacher. Ken's practice focuses on all aspects of general civil litigation with an emphasis on construction law, which includes the representation of contractors, developers, owners, and design professionals, contract and real property disputes, business and commercial matters, and insurance coverage and litigation issues. Ken's construction practice includes contract drafting, negotiation, bid protests, in-project consultation, and claims advice. Ken received his JD from Boston University School of Law in 1995. While in law school, he served as an articles and book review editor for the Boston University Public Interest Law Journal. Ken graduated from the University of California, Berkeley in 1992 with a bachelor's degree in history and political science. I'd like to thank both Ken and Scott for joining us today. These are longtime partners of our agency. This has kind of become a tradition over the years, doing this contract law update at the beginning of the year. And later on, I will come back on and introduce our final presenter, Mr. Aaron Silva. Gentlemen, the proverbial floor is yours.
Thank you, Edward. You had to dig deep for some of those comments, so thank you. So I'll turn it over to Ken to do some intros, as we are in our one of our conference rooms in our firm, but appropriately socially distanced here.
That's right. We have more than 6 feet between us, so no worries here. So good morning, everybody. Thank you so much for attending, and we want to thank Edward and Jillian for inviting us again to come and speak to you on the Bender U. We've done probably a dozen Bender U's through the years, and we obviously value the relationship that we have with them and all of you many who we do know from past years. So really the structure of today is we're going to start out and talk about construction, the new construction laws for 2021. I will say from the outset, it's a pretty lean year. You know, some years we have substantial changes. In the past, like Candace lien changes, indemnity law changes. As you'll see, I think we're going to speak about 8 laws or so, not a ton of real, meaningful changes, but some that you do need to know. We'll also go over some of the case law that came down in 2020 that could impact you as contractors or owners, et cetera. And then really the core of the seminar after that will be focused on the employment law changes, which I'm sure many of you want to know about. And our partner, Aaron Silva, is going to be the one who's going to be chatting about those.
And as Jillian indicated, please, for those of you who have been to some of the seminars Ken and I have put on over the years, definitely like to be interactive. So this is kind of a brave new world for us on the webinar circuit. But to the extent there are questions on any of our material or the cases or generally, please put them in the chat box and we'll take as many questions as we can as we're working through the material.
Yeah, and we don't mind being interrupted. So you don't necessarily have to save them to the end, to the Q&A session. If there's something that's a hot burning question or topic for you, throw it in the chat. We'll try to make sure we get to it. All right, so let's move on. So Edward already talked about Groundhog Day, but that's not the only significance of today. It's also National Tater Tot Day. So, which I don't know about you, I find that to be more relevant just given how much we do love tater tots and everything you can put on them. So just remember February 2nd, National Tater Tot Day.
And Edward, thanks again for stealing our thunder. Yes, it is Groundhog Day. Puxtawny Phil did see his shadow, as Edward said. And as we were walking in here this morning, I was asking, Aaron and Ken if they know any good Groundhog Day jokes, because I just keep hearing the same one over and over again. Dun, dun, dun.
And I will say this, many of you maybe lived on the East Coast or the Midwest, and I did go to law school in the East, and I lived through a few nor'easters. The thought of 6 more weeks of this type of winter for the East Coast, I feel sorry for them, but I'm happy I'm in California.
Absolutely. Okay, well, let's jump into some of the 2021 new construction laws. And as Ken indicated, there's not a lot of substantial changes this year. I suppose it's probably going to be, from your position as to the type of work that you do, but not a lot of really deep, meaningful, legal, impactful changes on the legislation side, such as a decade ago when we had the mechanics lien changes. And candidly, that's probably a good thing this year, given all of the pandemic and COVID-19 legislation that is impacting all of our companies and all of our businesses, that we're not dealing with some wholesale significant changes that may be really structurally impacting how some of you may be doing your business. And many times this is a ripe opportunity for the legislature to jump in and slip some things in bills. Nothing that really we have seen like that, but what we did is pick out kind of a smattering of what we expect maybe some of the things that may impact some of your companies as we move forward, and thought we'd highlight these for you on the legislative side. So the first is SB 588, which amends the Military and Veterans Code. And some of you may be saying, well, what does that have to do with construction? Well, for those of you, especially doing the work in the public works realm, there are DVBE or Disabled Veteran Business Enterprise requirements. And generally under the law, existing law, there's a 3% participation goal that occasionally may slide, but usually it's 3% to include DVBE enterprises on public contracts, depending on who the owner is. What this legislation does is it essentially puts a little more teeth into the DVBE requirements. And it requires that the certification that a public works contractor has to provide must be submitted in a timely manner and at a date set, generally the end of the project at final completion by the owner. And absent that certification being provided, there is the right of a public owner now to assert a $10,000 withhold from final payment, or to withhold the entire final payment if it's less than $10,000 and to set a time period. It has to be within 15 or 30 days for this DVBE certification to be provided. And if it's not provided, the owner can continue to withhold those monies forever. Okay, moving on to the next, SB 1189, which amends various portions of the Business and Professions Code, which primarily deal with, at least construction setting, the laws that are applicable to contractors licensing. And this is a bill that really arose out of some of the natural disasters that we've encountered over the last few years. And particularly SB 1189 arose out of the fires over the last few years in Sonoma and in the wine country. And in response to various homeowner complaints regarding contractors, or perhaps I should say entities and individuals who held themselves out as contractors to do restoration work and remodel work for properties and real property itself that had been damaged or destroyed by wildfires. And what essentially 1189 does is it creates, for the first time in a long while, a new classification of contractors' licenses. I'm sure all of you know there are generally three primary categories: your general engineering A, your general contractor B, and your specialty license C. Well, what this bill does is it creates a new classification of contractor license called a residential remodeling contractor's license. It's going to be known as a B2 license, if you see that. And essentially what that is it requires a business that, or a entity that wants to make improvements to or on existing residential wood frame structures, or the ground on which those structures sit, must use at least 3 unrelated building trades or crafts on a single project. And that also includes fire protection as one of those trades. It prohibits an entity that is holding itself out as a residential remodeling contractor from taking on any contract for a project unless that contract includes 3 or more unrelated trades or crafts, again, including fire protection, unless the contractor holds either the license classification for one of those scopes of work, or it subcontracts with another appropriately licensed contractor. And you might be asking, why was this law required? We can ask that a lot of the legislature. But essentially, this, again, it's a consumer protection law, because there were certain DAs in the Bay Area, but also throughout California, that looked at the definition of a home improvement contractor and a home improvement contract, and did not see in that definition the ability for the district attorney to essentially prosecute unlicensed entities, unlicensed contractors who were engaging in reconstruction, restoration, and rebuilding when a natural disaster such as a wildfire occurs. So the biggest takeaway on this law is home improvements now include the definition of reconstruction, rebuilding, restoration from natural disasters, and it segregates the home improvement to the B2 and traditional home improvement for actual construction versus reconstruction and restorations.
Yeah, and don't forget too, remember, for home improvement contractors in general, there are specific contract requirements which can be found in the Business Professions Code sections, and so which have mandatory disclosures regarding liens, change orders, and other important terms. So not only do we have a change now or an augmentation of the licensure, but also remember you still have to comply with the contractual requirements.
Next piece of legislation we'll talk about briefly, AB 2471, also deals with generally home improvement contracts, but essentially this is yet another consumer protection-led piece of legislation that was passed in the contracting realm. Essentially, it extends a cancellation period for senior citizens with what we can refer to as door-to-door contracts. But essentially, contracts for home solicitation, contracts for improvement, for PACE or property access clean energy assessment contracts, various service and repair contracts, various sales contracts, essentially protect seniors by allowing them an additional 2 days from the current 3-day cancellation period, increasing that to 5 business days to cancel. So I think that the takeaway for those on this call, to the extent that you may be working in the home improvement area, make sure that to the extent you have your cancellation forms, that you have your traditional cancellation form, but that you also have modify that accordingly if you have a sale to a senior citizen, which is defined under this legislation as an individual over 65 years of age, to make sure that you actually are using the appropriate form.
Yeah, and our understanding is that the form itself isn't different than the 3-day cancellation. It's just changing 3 to 5.
Right.
So that we're not aware of any additional terms that need to be in that cancellation form, or where it's supposed to be located in the contract, or what notice is to be provided. So it really is just making sure that you have that additional form either as an exhibit or attached or referenced in the contract.
And you know, for many contractors might be easier and safer rather than actually trying to guess or figure out an age, or perhaps have that embarrassing conversation with a customer, just to default to the 5-day form. So that's, I think, at least one takeaway to avoid issues, because if you were to use an improper form and there were an issue or complaint asserted to the CSLB, disciplinary action could be taken for utilizing the wrong cancellation date. All right, and moving out of the home improvement realm, SB 865 was passed this year and amended various sections of the government code here in California. Essentially, this is called the Dig Safe Act. And this act makes some modifications to the current California Underground Facility Safe Excavation Board and requirements. And essentially, it puts some more onus and some more requirements on both excavators or contractors and operators with respect to providing information and also providing a static mapping of underground work that has been performed. What this bill requires is that the regional notification centers, so the Northern and Southern California USA sites, need to be provided additional information with respect to excavations. It requires the USA sites for Northern and Southern California to report to the board that oversees this act quarterly with respect to all subsurface installations, except for specified oil and gas lines that are 3 inches or less in diameter in certain areas, and that they must be mapped using a geographic information system, which is not defined. But essentially, what that is, it's going to be an electronic locating system that shows both the horizontal and vertical locations of the installations. And it also requires excavators or operators to notify the regional notification center 48 hours after discovering or causing any damage to current subsurface installations. So again, common sense, but it closes a few of what loopholes, if you will, that the legislators perceived were missing in the current dig safe requirements.
All right, well, the next two new laws we're going to talk about have to do with licensing, the CSLB. Seems like every year we have a few additions or changes to license laws, and this year is no exception. I'm not sure anybody here is a tree trimming contractor, has that specialty license, but if you are, this is relevant. It may be relevant to your projects anyway, in that the AB 2210 amended a few of the sections of this professions code and kind of tightened up some of the requirements and made it a little more stringent on tree contractors, including authorizing disciplinary action against contractors who regarding tree work, including maintenance or removal, without regard to whether death or serious injury to an employee resulted. So in other words, if they violate any of the rules or the laws, you don't need, that follow-on action or follow-on injury or damages. They can still be disciplined regardless. It also requires the registrar to initiate disciplinary action. If there's a willful or deliberate violation of any tree trimming regulations, and extends the time to bring the action from 180 days to 18 months. So from 6 months to 18 months. So really, I think this is kind of hand in hand with the wildfires and some of the changes, some of the entities that were out there that maybe weren't properly licensed, doing proper work on tree trimming and tree cutting. So again, just another way of tightening the noose a little bit around the neck of contractors, but nonetheless probably still valid and necessary. The other change, the new law, is SB 1474. So if a license expires, or typically if it expires, you, as a contractor, you can only have it renewed or reinstated after that time if you somehow show substantial compliance, that you didn't know that your license was expiring, you didn't receive notice, or that you took reasonable steps. In fact, the existing law says that the registrar for the CSLB can grant a retroactive renewal of a license within 90 days if the contractor shows that the failure to renew was due to circumstances beyond their control, and then they filed the application. So again, it's a substantial compliance argument that we always see, which is, I didn't get it. It was sent to the wrong address. I sent everything in and it sat with the CSLB, which happens. And we know that's been happening more and more with the bureaucracy that we're dealing with and the staff cuts that everybody's experiencing. Well, this law loosens that up a little bit. And what it does is it deletes the requirement that you actually show that there were circumstances beyond your control for the renewal. And now it requires the CSLB to retroactively reinstate the license if within 90 days of the expiration, the contractor actually completes the renewal application and provides the appropriate fees. And there may be delinquency fees and penalties tied to that, which obviously will be probably relatively minor compared to the impact of not being properly licensed. So while we often see the legislature, the CSLB making things more difficult for contractors, this actually goes the other way. So the trend here is to loosen it up and take out the subjective analysis of, did somebody do something proper? Was it circumstances beyond their control? Did I get it in the right address? All those things now can go out by the wayside, and we can just focus on within 90 days, did they provide a renewal application and pay the appropriate fees? So I see this as a win for contractors, which we don't often get to say. All right, the next two laws that we're going to talk about deal with prevailing wage. One question that we get a lot from clients is this kind of public-private hybrid in whether prevailing wages apply. It could be a private project, but you may have public funding, a public subsidy. What does that mean? Well, you can look at the Labor Code section 720, which does kind of set the standards for prevailing wage. And this AB 2231 amends 1720. And what it does is it provides a safe harbor for payment of prevailing wages when the public subsidy for the project is both less than $600,000 and less than 2% of the total project cost. So now they've actually set a monetary limit to analyze whether or not prevailing wages are going to apply in these hybrid type projects, where there may be a public subsidy, but not necessarily a public owner. So we're hoping this may provide a little bit of clarity, hopefully, but at least it's, again, a step in the right direction. For single-family residential projects, it also provides a safe harbor for the payment of prevailing wages. A public subsidy is less than 2% of the total project cost. So again, you have to look at the type of project and to see whether or not there's subsidy or not. And this is going to apply to projects starting July 1st, 2021. So if you have a current project, this amendment will not apply, or if a project is advertised or awarded before July 1st of this year, it again is not going to apply. I will say this, for any of you who are trying to understand prevailing wage or what projects prevailing wage may apply, 1720 is a rather long statute, but one that you probably do need to read to really understand, although I think Aaron can attest to this. We read it often and it's really not 100% clear most of the time.
Absolutely not.
And he agrees. And he is our prevailing wage guru, so if there's questions folks have, usually Aaron's the one that we call and ask about that. So again, I think these two, similar to the license laws, this is a good change and one that hopefully will clear up for certain projects some of the requirements. And then finally, the last prevailing wage law change has to do with the disclosure of skilled and trained workforce. And this amends Public Contract Code sections 2600 and 2600.5. It's AB 2311. As many of you know, skilled and trained workforce requirements are required for different projects, mostly design, build, and leaseback projects where we see those with certain percentages of apprenticeship and other requirements, which I think is going up every year. I don't know, is it 60% now? 40 or 60%? I think every year it augments. So what this law says is it requires public entities, when use of skilled and trained workforce is required, to include in all bid documents, construction contracts, a notice that the project is subject to skilled and trained workforce requirements. Makes sense. Now, what happens if the public entity fails to provide that notice? The public entity shall not be excused from the requirement to obtain the enforceable commitment, and that a bidder, contractor, or other entity is not excused from the obligation to use a skilled or trained workforce. So wonderful for contractors, right? Owners have to provide this notice, and in most of the contracts that we review for these projects, you do see them disclosing. But even if they don't, you contractors are still on the hook and are still obligated to know that you have a skilled and trained workforce requirement. So I guess it's a good law, but it doesn't get you off the hook, unfortunately. So you better do your research. Okay. So like we said in the beginning, it was a rather lean year for new construction laws. I think you can attest to that, although I think we've covered the 8 main ones. I see from the chat there doesn't appear to be any questions, which is it's a good thing. Nothing too confusing or complicated. So what we want to dive into now for the rest of Scott's and my time are just some of the new construction law cases that came down in 2020. And the first one we'll talk about is the Crow's Note Construction v. Travelers Casualty case. I'm not going to pick on Travelers. I think there may be some Travelers folks here attending our seminar. But what this case basically talked about was trying to reconcile a pay when paid provision and the ability for a subcontractor to make a payment bond claim on a public works project. So just as a summary again, pay when paid provisions are legal. Pay if paid are not on public projects. And pay when paid basically says subcontractor, you'll get paid when the general contractor gets paid. And most contracts say that's within a reasonable time. And the reasonable time, especially on this particular case, was when the prime contractor has exhausted and fulfilled all legal claims and rights against the owner, which means litigation or arbitration, which, as many as you know, can take years. And that arguably is a bar on the subcontractor from pursuing the prime contractor legally. Now, what's the juxtaposition to that on a payment bond claim? A payment bond claim is a claim against a surety by the subcontractor, which the lawsuit has to be filed within 6 months of the last day that a subcontractor can serve a stop notice. So ostensibly, that is 7 months from completion. So the dilemma we have here is you have to sue within 7 months on the payment bond, but pay when paid could be years. So this court reconciled that dilemma and basically said that a pay when paid provision does not bar and does not limit a subcontractor's right, which is statutory under Civil Code Section 8122, to pursue a payment bond. So the trial court, that was the trial court's ruling, and the appellate court affirmed that. So really, what is the the lesson learned from this? If you're a subcontractor, don't sit on your rights.
Well, that and that's an important concept, because depending on the nature of the claim type of project, a public project, of course, that the Crosno decision may absolutely gut a pay when paid provision, because if you as a contractor or a sub have a right to pursue a payment bond claim actively, the payment bond surety steps into the shoes of the contractor. So you'd essentially be pursuing those claims against the surety directly, yet it would really be the rights of the contractor that you would be pursuing and going after. So that's it's going to be interesting how that plays out, because you'll have you're going to find yourself potentially on a public project with a payment issue being able to pursue and move forward on a payment bond claim, yet there being almost an effective stay against a direct claim against a contractor that owes those dollars. And it's going to be interesting to see how courts actually reconcile that, because if you're going to be pursuing a claim against a payment bond contractor, you're essentially pursuing the contractor who owes those dollars.
Yeah, and to make things even more complicated, we're not sure how this will play out. A lot of times, and we have existing litigation now, where you may have the payment claim from the from the prime contract against the owner with subs involved, maybe in binding arbitration, and yet the surety is not a party to that binding arbitration. So the question is, can you pursue the surety in court at the same time as there's a binding arbitration? And it's a complicated legal issue, but this case basically affirms that you can potentially go down multiple paths, which may be conflicting paths, and we're not sure yet how the courts are going to reconcile those, depending on your case or on your contract terms. So we may see ultimately in contracts, we may see carve-outs for this. We may see limitations. We may see people trying to clarify what happens when you have this situation. So we'll probably see some pretty creative drafting. But the court did not give, the Crosno court, while it said move ahead to the subcontractor, it didn't give us guidance in terms of what's going to happen once we're in the court system against the surety. Okay. The next case that came down was the Eisenberg Village case, and this one is a very interesting case. So as Scott and I have given lots of seminars, and especially for Bender U, regarding license laws and the draconian law of Business Professions Code 7031B, which is the disgorgement law. And as many of you know, that law basically says that if a contractor is not properly licensed, the entity that has paid them may seek disgorgement of all amounts paid to that contractor. And the law is set up in such a way that even if you are unlicensed for arguably 1 day on performance of your contract, the entity that paid you may be able to disgorge 100% of what they paid you. And that's why we over and over and over emphasize you've got to have your licensure in place. And if you have a licensure lag, we better remedy it immediately. So what that means is that an entity or a person can sue under Business Professions Code 7031B for disgorgement. So what this case dealt with was, well, how much time do you have to sue? And so it's dealing with what is a statute of limitations for that claim. So as many of you know, for a negligence action, you could have a couple years all the way up to 4 years for patent defects, 10 years for latent defects. That's a statute of repose. Breach of contract, you typically would have a written contract, 4 years to sue for a breach of written contract. Well, how long do you have to sue for under 7031B? And I think up until this point, a lot of folks thought, well, you probably have the same amount of time as a breach of contract. Maybe 4 years, maybe 3 years, maybe 2 years. Well, this court said, no, 7031B is a penalty. And under Code of Civil Procedure 340A, the statute of limitations is 1 year for completion of the project. So if you are an owner or you're a prime contractor or a subcontractor, and you want to pursue a 7031B claim, you have 1 year for completion of the project. Now, what the court grappled with also was the discovery rule. And that means, what if I didn't know the contractor was unlicensed or not duly licensed during this period? What if I discovered it 3 years from now? Doesn't matter. They don't want to look at the discovery rule. All they're going to look at is 1 year from completion. And in the Eisenberg case, the fact pattern was that the contractor was arguably not duly licensed because the RME, the responsible managing employee, was somebody who was in California, but then during the project moved to Boston and did work in Boston, had no involvement with California. So what the argument was they were not a bona fide employee and therefore not a proper RME, and therefore the contractor was not properly licensed. Well, that was only discovered during discovery in the case, or actually some years later, where they figured out, okay, well, this wasn't a bona fide employee. You probably would never know that during the course of the project. So if somebody really wants to make this claim, they better do their due diligence early, and this clarifies that issue. And so probably for unlicensed contractors, it's a good ruling, or contractors who were duly licensed, it's a good ruling, but one that, again, I think really does clarify the law.
So Ken, we've got a question. Let me go back for a moment to the Crosno matter. And the question is, does the change in pay when paid apply to federal projects?
Yeah, I think the answer is typically no. The federal law is different on pay when paid, pay if paid. So unless the project specifically says California law is the substantive law and applies, it's not going to. So this really just applies to California municipal public agency projects.
Yep, I would agree with that. Okay, let's jump forward. We got a couple more cases before we turn it over to Aaron to educate us all on employment laws, employment law changes. C.W. Johnson and Sons versus Carpenter. And this is yet another in the line of license cases that have come out the last number of years. And again, for those of you who've heard Ken and I and on some of our seminars, we've talked quite a bit about licensure issues and the importance of licensure. And as you heard Ken a moment ago state, you need to plead and prove as a contractor that you're licensed to get your foot in the door in order to pursue a claim with respect to additional funds. So that takes us to this Johnson case. And on the facts, it's unfortunate but unremarkable. The contractor, C.W. Johnson and Sons, was a family-owned contractor. The father and son ran the business. Father passed away in 2016. For some reason, the son didn't know that the father was the license qualifier, and they merrily go on their way doing various residential projects for years. And of course, Murphy's Law, one of the project owners sues Johnson for negligence and poor construction and defect issues and the like, and asserts various licensure claims, bringing to the surface that you're not licensed. The license qualifier had passed away. Immediately upon learning that, the son applies to the CSLB and gets the license reinstated within the span of a month or so. Now, this is not a situation where you would be saved under the new legislation that Ken talked about, because remember, that's a 90-day window. Here, we're over 2 years. And this case involves and discusses substantial compliance issues. But essentially, what this court found is a little different than I think some other cases we've seen come down, which is even though the contractor, in pursuing its claim in a complaint for, this would be a cross complaint, excuse me, for unpaid monies, did not plead that they were a licensed contractor at all times during the project. They did claim facts to allege that because of the what the contractor claimed is the unknown situation of the license expiring due to the passing of the license holder, that they qualified under substantial compliance. Generally, we see courts take a very black and white view of this and would kick that complaint out for failure to plead. What this court did was said, no, you have at least pled, you've got your foot in the door as a contractor to make this claim. So you've at least pled that you may comply with substantial compliance, but your next stop is now an evidentiary hearing to make a determination as to whether or not you satisfy the substantial compliance requirements, which again is that a contractor had to have been previously duly licensed, it acted reasonably and in good faith to maintain its licensure, and that it acted promptly and in good faith when it understood that its license had expired. So while certainly this contractor may have won the battle, it's probably going to lose the war, because courts really look at substantial compliance from the evidentiary hearings very strictly. And it's going to be very difficult for this contractor to say that, hey, they had a good faith basis over 2 years to know that that they thought they were licensed and weren't. It's not that doesn't seem reasonable on its face, but at least this is an instance where if as a contractor you find yourself with a gap in licensure, there's at least a chance that you can move forward. Okay, and then the last case is Hansel Phelps Construction versus CDCR. Bad year for Hansel Phelps. They had a couple of bad decisions, and I say bad and going adverse to them. This is one of those. So in our practice, Ken and I do a lot of bid protest work on public projects. And we routinely field questions from clients is what do I get out of this bid protest? What's this going to do for me? And obviously, it depends on which side of the fence you're sitting on, right? Are you the apparent low bidder, or are you the challenging bidder? So it really depends, but you may get a whole lot of nothing, because some public entities just ignore and don't even entertain protests, or just routinely reject them just because, or maybe you win the opportunity to rebid the project again, yay, or maybe you find yourself in a very interesting position where a contract is awarded, work starts, and a court orders the contract invalid and illegal, and what happens to the parties? And that's the situation that we find ourselves in the Hansel Phelps case. So there in San Diego, Hansel Phelps was awarded a public contract through the CDCR. Another bid, this is about $100 million project, so a relatively substantial project. Another bidder challenged the award. CDCR ignored it and basically said, we don't have to answer this bid protest. They went ahead and allowed Hansel Phelps to start construction. This aggrieved second low contractor filed an action in San Diego trial court, a writ, and was able to have that court issue an injunction to stop the project on a finding that the contract was illegally let, because Hansel Phelps essentially submitted within 24 hours after its bid, not just information on percentages on subcontractors, but substantive information that modified its bid. So you've got a big mess. And Hansel Phelps, rather than challenging that court ruling, said, yeah, okay, you're probably right. We're just going to now file our own action in court under the public contract code. And we're not going to say that we should have been awarded the project, but we're going to say that in the span of time we were working on the project before the injunction, we get all of our out-of-pocket costs, which was to the tune of about $3.5 to $4 million over a couple months of initial work on this project. And this case focuses on essentially Public Code 5110, which for those of you that are do work in the public contracting realm is going to be important on protest cases. To the extent that there's a challenge to a contract, Public Contract Code 5110 allows a public owner to award the contract and allow it to move forward. However, if as here there's a finding by a court that the contract was illegal, it allows contractor to recover its out-of-pocket costs if the contract was invalidated due to a defect in the competitive bidding process caused solely by the public entity. So Hansel Phelps took a very interesting position here. They essentially said, public entity, you shouldn't have awarded this contract to us at all because our bid was not responsive because we changed it and you awarded this illegally. Believe it or not, the trial court agreed with that and initially allowed Hansel Phelps to recover all its out-of-pocket costs. Now on appeal, the appellate court said, no. What that statute provides is that if the underlying contract's invalidated as a result of the conduct of the public entity, such as the actual bidding documents contained something that made them illegal or unable to be awarded because they were contrary to law, then contractor may recover. But to the extent a contractor submits a bid, public entity elects to accept that bid, that action itself does not constitute the underlying wrong. So the takeaway here is it's a bit convoluted, but it provides a little bit more focus for contractors and again, for public entities as well to step carefully when there's a challenge to a contract as to whether or not you actually let that project move forward while there's a pending challenge.
Or perhaps the public owner needs to suspend the project pending the lawsuit and challenging the bid.
Right, which is not always possible based on timing and funding of projects, but it will be interesting to see how some public owners, especially on larger projects with contentious protests that may evolve into a writ or a challenge to the legality of the projects. This is kind of a warning shot for public entities as far as whether they should be moving forward with the project, even though this turned out okay for CDCR. This was a long drawn out legal process. Do we have any questions? No, okay, no questions. That I think takes us to the end of the riveting construction law update. We're going to now turn this over to our partner, Aaron Silva.
Hey, thanks guys. Great presentation. To continue our groundhog theme, I'll give you a little musical interlude. Fun fact, the Pennsylvania polka written by Frank Yankovic. Yes, that would be Weird Al Yankovic's father. Big polka guy. Okay, Aaron, let me see if I get this right. From the mighty peaks of the Sierra Nevadas to the soaring towers of San Francisco and all parts in between, I'd like to introduce you to Mr. Aaron Silva. Aaron is a partner with the Labor and Employment Practice Team. He has an extensive background defending employers before state and federal courts and several administrative boards, including the National Labor Relations Board, the California Division of Labor Standards Enforcement, the California Workers' Compensation Appeals Board, the California Unemployment Insurance Appeals Board, and everyone's favorite Cal OSHA Appeals Board. Aaron was awarded his JD from the University of California, Davis School of Law. Prior to joining Murphy Austin in 2007, he worked for both the Cal OSHA Appeals Board and the California Public Employment Relations Board. Aaron, we're so happy to have you here today, and I'm sure you might have one or two topics to cover that are pertinent to all the folks listening in today. So I will turn it over to you, Aaron. It's all yours.
Thank you very much. Okay, let's see. I'm ready to go? Okay, here we go. Well, hello, everyone. Nice to be with you today. So 2020, we have a few things to talk about. 2021, a few more things to talk about. But whenever I do these presentations, I always start out with the same thing. The minimum wage is going up. So be mindful of that. It's still on two different paths depending on how many employees that you have. If you got more than 26, you're at $14 an hour. If you have 25 or fewer, that's $13 an hour. And remember, this affects your exempt employees too. Why? Because under the to be an exempt employee, you have to earn more than 2 times the state's minimum wage on a monthly basis. So obviously, if the minimum wage is going up, that means the amount that you have to pay your exempt employees to have them remain exempt is going to go up as well. So besides that, I'm sure you all are aware that there is a very complex regulatory scheme that came out this year. I'm sure that all of you want to talk about it. It's all on your mind. So click, these are yours. So here we go. So what's that complex scheme? Here we go. New sexual harassment regulations. That's what everyone's talking about. That's right. The Department of Fair Employment and Housing, if you didn't notice, did some regulations this year, and one of them has to deal with sexual harassment. So all employers in the state of California, if you have more than 5 employees, and even if you have less, you should have this too, you need to have some sort of harassment policy, preferably in a handbook. In 2015, we got very detailed regulations as to what those policies need to provide for. So if you haven't updated those since 2015, or you don't have a sexual harassment policy, or you don't have a handbook, you need to do it now. So one of the updates that we got this year is now your sexual harassment policy has to include a link to the Department of Fair Employment and Housing's sexual harassment online training courses. So basically, when I'm doing amendments to plans, I just add in a line or two about this. So sexual harassment training, other little details that we got from the regulations. The required training may be completed in segments of at least 30 minutes each. So instead of training every 2 years, your rank and file and your supervisors, you could do half of that training annually. Quite frankly, I don't know why you would do that. I would rather just get it all out of the way at one time every 2 years. So that's what I would recommend. But if you want to do some sort of training 30 minutes a year on sexual harassment, now you have the ability to do that. So reminder, every 2 years, your supervisors need at least 2 hours of training on sexual harassment and related topics. And your non-supervisors every 2 years need at least 1 hour of training. When I do training sessions, when I used to do them in person, and now I do them virtually, I would do everyone in the same room or same virtual room. For the first hour, that would be non-supervisors and supervisors, and that would be just going over just general stuff like what is sexual harassment, here are the requirements, things along those lines, general stuff. Then I excuse the non-supervisors after the first hour, take a little break, bring back the supervisors, and then we talk for an hour about how easy it is to sue employers and why this is what you need to look out for and things like that. So that's sexual harassment, but that was not all that that department was doing. There we go. Because we also got regulations from that department regarding pre-employment inquiries and job applications. So for the past few years, we've had somewhat of an attack on form job applications. So you're no longer able to ask things about, Do you have a felony? It's the ban the box law and regulations. You can't ask about how much a person made at their prior job because of sex discrimination concerns. This is just continuing that trend. So of stuff you cannot ask an applicant. So according to our new regulations, you cannot request, don't request scheduling information or applicant availability that may in a way ascertain the applicant's religion, disability, or their medical conditions. So instead you can ask things like, other than being off for reasons related to your religion, disability, or medical condition, are there any days or times when you are unable to work? So that easily flows off your tongue and is easily understandable. Of course, that's not the case. But now here's where we're at, right? We have to get that sort of detail. So we originally saw that sort of detail and qualifications with questions on like disability in the past. So that's not new, but this is pretty expansive. So be mindful of that. If you have an online application that you're using, you have to include a mechanism for the applicant to request an accommodation. So be mindful of that. Basically what this is saying is, if you use a form job application, you need to go back and make sure it's really in compliance. Because when I get my letters from my plaintiff's attorneys asking for all documents, you know, depending on what the firm is, you know, some firms I know immediately what they're looking for. But, you know, if I'm looking at a job application and it's still asking, have you ever been convicted of a crime, or have you ever been arrested, which is even worse. I mean, I know immediately that that's a potential, I got a potential class action there. So that kind of just makes my heart sink a little bit. So you need to be mindful of what you're asking about of your applicants and your applications. Just relying on, you know, a form that you got online, who knows what jurisdiction that came out of. And, you know, if you're using some sort of payroll service or something along those lines, that's fine. But what inevitably happens, if something goes wrong is, you know, your payroll service says, well, that's your issue, and courts and plaintiffs' attorneys have the same attitude, is that you need to be diligent in what you're actually putting out there and asking of your employees, or your applicants at least. So review that. The question is, so I can see the chat, right? So I can see questions. And by the way, I very much prefer to get the questions while I'm talking about the subject instead of at the end. It says, when retraining for harassment, is there a window to how much time you get to retrain, or do we need to retrain before their 2-year certificate applies? Do it before. So I usually, you know, I have an idea as to when training is going to expire, and then I recommend doing it about a month beforehand. That's the safest way to do it. But I would not be in the position where, you know, it has been more than 2 years than I have done my training. The reason is that there is a specific allegation called failure to prevent harassment, discrimination, and retaliation that exists under our EEO law in the state of California, which is called the Fair Employment and Housing Act. And if you fail to provide that training, that could land you in a lot of trouble with that. So I would do it before it expires. Okay, let's see. There we go. Pre-employment inquiries continued. The regulations go on to state that you need to remove questions or inquiries that may reveal an applicant's age, like their date of birth or graduation dates. I don't think there's anything new in that. That had always been advisable. But the regulations do now we have regulations specifically saying that they prohibit online applications from requiring applicants to like enter their age in order to access or complete an application, or use drop-down menus that contain age-based cutoff dates, or use automated criteria to screen out applicants that are 4 years or older. I didn't know that this existed, but apparently it does, and it's a problem according to the state of California. So to the extent that you have online applications that you're using and it does any of this stuff, just going to that bottom point, you need to be sure that they comply with California law and regulations once again. Okay, recruiting and advertising. So this again goes to our regulations. When you're recruiting in your advertising, just generally don't use language in recruiting advertising materials that implies that you're seeking a younger candidate. Remember, according to the federal government, into the state of California, if you are 40 years or older, you are an older worker, which for this 39-year-old is hard to swallow. but that is the case. So the regulations prohibit anything that a reasonable person would interpret it as deterring or limiting employment of those 40 years or over, unless there's a bona fide occupational qualification for having someone that is younger. So examples, you wouldn't want to say things that you're looking for young applicants for recent college graduates or a digital native. So something along those lines. So once again, just be mindful of what you're putting out there. Recruiting and advertising. Regulations can create a slippery slope, obviously. So even things like asking for fresh ideas or new perspectives or someone that's going to take us into the future, all that sort of stuff, that may be problematic now. So we're going to have to probably go back to just more neutral, bland advertising and recruiting, which I think is going to cause some problems for those that are in the industries that are strategically looking for people to fill positions like recruiters and things along those lines. But I mean, these regulations, like a lot of stuff in California, is taking a lot of tools away from employers as far as how they can recruit and retain people. Finally, in regards to the regulations, we now have a new presumption of age discrimination for practices that have an adverse impact on applicants or employees 40 or over, even if the practice or policy looks neutral and doesn't specifically or expressly target older workers. So for somewhat of an analogy, you might remember that there standardized testing for schools back in the day, like the SAT, came under attack for being discriminatory against minorities. So even though everyone takes the same SAT, regardless of their race, the theory is that, well, just how the way it's written and how it is actually applied is discriminatory. So that's called a facially neutral discriminatory act. And so essentially this is what this is doing. So even if you have a facially neutral act that applies to everyone, but somehow the effect is that it adversely affects those that are 40 years or over, that is now illegal. So how do you overcome that? You got to show that it's job related and consistent with business necessity, which is easier sounding than it actually is in practice to show. But here's an example that comes from the regulation itself. An employer's preference to retain a lower paid group of workers in and of itself may now not be sufficient to rebut this presumption if the business purpose, which in this example is saving money, could have been achieved in a manner that didn't adversely impact older workers. The theory there being that if you want to keep lower paid workers, that's going to probably tend to be younger workers. So that means that your younger workers are going to be retaining, your older workers are not. And that can now be challenged. It always could be challenged, but now we actually have it in regulations. And so effectively, you're going to have to justify your business purpose as to why you're making the decisions that you are if it has that sort of impact. Like I said, this already existed in case law for things like race under our EO laws, but now we have regulations that apply it to age. So with that, I think that's the biggest topic that everyone talks about, unless anyone out there is, anyone hear about COVID? So I'm assuming you probably have, because it's like 80% of my practice at this point. So we have several COVID things. Here's how I wrote this presentation, because when I give these presentations, as a lot of you know, this is not my first rodeo with new laws. I do have a program that I go out on the road with. So I've given this presentation several times. Sometimes I've done it in 20 minutes. The longest one was 3 hours. So I've written this presentation with the bulk of it being COVID stuff, because that's where most of the questions are. There are other things at the back end that would be nice to cover. There's one thing that I definitely need to cover that is not COVID related, but if you have questions, I understand that. So if you could keep it to the laws that we're covering, that's great. But I know that's just not practical. So just ask me whatever you want to with COVID and we'll just go from there. So, but this is somewhat structured in talking about new laws and regulations. So let's talk a little bit about, before we go into the first law, about just where we're at, okay? So this all dropped in the spring. And what we had is that the legislature wasn't doing anything. back in the spring with this, and Congress was still in session. So we got a little bit out of Congress. We got the Family First Corona Response Act. We got the PPP stuff. That came out pretty quickly, but where most of the activity was happening in California was in two sources. The first one, or actually three. The first one was coming from the governor and executive orders. The number two source was from administrative agencies. And then three were from local governments, specifically counties, that were issuing guidance and things you needed to do, stuff like that. The problem is, and it remains a problem today, is that none of these sources, for the most part, talk to each other. So a lot of times it was contradictory. So at a certain point when this first arose, Murphy Austin was doing daily email updates about what is this agency doing on a daily basis for, I think it was close to 2 months. Every single day we were getting something new. So there's a tremendous amount of information that was coming. And then the legislature came back. And so they decided that they were going to get involved. So let's talk about a few of the laws that we got. So what we're going to talk about is stuff that is relatively new. So stuff we got out from the legislature and the Cal OSHA regulations. So I'm not going to talk about Family First Corona Response Act unless someone asks about it. That expired at the end of the year. It was not mandatorily expanded. You still can claim the tax credits if you voluntarily do that till the end of March. But for that sort of stuff, I'm not going to talk about it unless someone specifically asks me about it. I just don't have time. So let's talk about the new stuff, right? So the first one, SB 1159, is about workers' compensation. So a little bit of history. Back in March, the governor issued an executive order that created a rebuttal presumption that effectively, if an employee went to work and within 14 days of going to work, they tested positive with COVID-19, there was a presumption that they got it at work, and therefore it was covered by workers' comp. That was an executive order that applied until July 5th of 2020. It was subject to a tremendous amount of criticism. Some of you know that some of our state legislators individually have sued the governor regarding these executive orders, a few of them in particular, but basically the argument is that there's a specific act that allows the governor to do executive orders, and that act is either unconstitutional or is acting outside the limits of it. So that's the background. That's what we had back in March. So that went to July 5th, 2020. So the legislature was concerned about this. So what they did is they came in and they did a couple of things. They said, okay, well, that executive order that was done in the spring and it expired July 5th, but we, the legislature, are going to go ahead and pass that into law. And the governor is going to sign that. So it's going to be retroactive. So we're going to deal with any sorts of challenges that this was unconstitutional or bypass the legislative process aren't going to exist anymore. So great. That was for stuff happening prior to July 5th of 2020. But then the legislature went the next step and said, well, the idea is good, so we're going to extend that out. So it is from those infected from July 6th of 2020. So note that is the day after the executive order applied until January 1st of 2023. So this exists for a while. It creates a disputable presumption. We'll talk about that term for workers' comp purposes, that an employee that is working for an employer with 5 or more employees, right? So there's a threshold, who got COVID at the workplace, or who got COVID and were at the workplace during an outbreak, that becomes a workers' comp claim. So let's talk about a few of these terms that we have here. The first one is outbreak. What's an outbreak? So an outbreak for employers that have less than 100 employees, because it depends on if you have more than or under 100 employees is going to determine our thresholds. For outbreak, for those of you with under 100 employees, what's an outbreak? Within 14 calendar days, 4 or more employees test positive. But if you're an employer with more than 100 employees, it is 4%, not for individuals, but 4% of employees who test positive within a 14-day calendar period. You can also get an outbreak, and it's deemed to occur if you're effectively closed down by the local health department or OSHA or a similar agency like that, and they tell you that you had an outbreak. So that's our first term that we need to define. On. So what is the law for those infections that happen after July 6th? The claimant's administrator So your workers' comp claim administrator has 45 days to deny the claim or the injury is presumed compensable. But like I say, this law created a disputable presumption that if there was an outbreak and you have 5 or more employees, that this is workers' comp covered. But how do you dispute that presumption? The governor, back when he did his executive order, didn't have any examples, and the agencies that were trying to interpret that order didn't really give us any guidance. The legislature, somewhat to their credit, does give us a few examples of how you can do that. So how can you dispute the presumption? 1, well, you look at what the employer's efforts were to reduce potential workplace transmission of COVID. So this kind of ties into everything that you're getting from the administrative agencies, from your counties, things along those lines. The question is, are you following that stuff? So, you know, are you putting into place, as we're going to talk about, did you modify your IIPP? Did you do the Cal/OSHA COVID prevention program? Is that in place? If your county has specific requirements for your workplace, are you following them? If your city has requirements for your workplace, are you following those? So for all of those individuals or employers that are asking, well, you know, why do I need to follow all this stuff that's coming out? I just want to get employees back into the workplace. Here's one of the reasons why. It is at least a way to dispute a presumption that if someone gets sick in the workplace, that's workers' comp covered, and you're on the hook for it. So that's the first example. That's probably going to be, I would think, the most popular. Second one, evidence of an employee's other risk factors for COVID, to the extent that plays a role. The second most important out of the 3, in my opinion, is non-occupational risk of COVID-19 infection, such as employees outside of the workplace. So when I get my COVID-19 calls from a client, someone is sick with COVID-19, what do I do? Usually if you've never dealt with this situation, there's usually some panic involved in that, which is understandable. But one of the things that you do need to talk about, and this comes from the Cal/OSHA regulations, is you need to talk to the infected person, because you need to find out who within the workplace that person came into contact with, and if they were a close contact, which we'll talk about in a little bit. You would be surprised, a lot of times you'll find that the employee that is infected has an idea as to how they got infected. So, you know, most of the time, to be quite honest, it's the gatherings. So, you know, I went to a birthday party, you know, it was a Thanksgiving get together, I was at a funeral, you know, and I hugged someone that, you know, 2 days later, it turned out that they had COVID. So employees are oftentimes very upfront about what they think happened, which is nice for this particular defense. So be mindful of that. You know, but still, you know, when this first arose back in the summer, so we're still under the executive order, I remember talking to clients, and this is during 4th of July, and, you know, and when protests were happening, things along those lines, and people were posting things on social media where they were in these large gatherings. So that was good information to have as far as being able to rebut that presumption. So before we go on to the next slide, question: for employers that have multi-county job sites, do we need to follow each county or city guidelines and not our corporate office? I don't understand the last part of that, but the question as far as for multi-county job sites, yeah, you do. So luckily, for the most part, they tend to mesh fairly well together if you're in a situation where it's county by county. I mean, that's not necessarily always the case, right? You could have a Sacramento County, El Dorado County type situation, but generally what you're going to want to do is you're going to want to follow the more stringent requirements as it pertains to your job sites. And as far as with your corporate office, I'm presuming your corporate office is probably within just one county, so it doesn't have 2 county lines, or it's not within 2 counties. So for your corporate office, you would follow whatever your corporate, whatever county your corporate office is actually in. Okay, going on, still on the workers' comp law. So with employers with 5 or more employees, if you know that one single employee tested positive, you need to notify your workers' comp carrier within 3 business days. This is different than what we were just talking about. We were talking about workers' comp claims. This is just, if you find out that an employee tested positive, you just need to notify your workers' comp carrier within 3 business days. That does not mean that that's going to be a workers' comp claim. but you still need to let your workers' comp carrier know about that, presumably because they are going to be tracking this information as well. So according to the law, the carrier is going to, or as an employer, you need to provide this sort of information to your carrier, the date when you found out what was going on, the employee's work site within 14 days prior to the test that they got tested, which presumably they did, the numbers of employees at each work site where the employee worked 45 days prior, so this is a little bit bigger, and then if you don't submit this information or you provide misleading information, there is a $10,000 fine. So that is our big workers' comp law. But in my opinion, the most significant law, not to say that they're all not significant, there we go, is going to be, excuse me, I messed it up, AB 685. So what AB 685 does is, okay, now we are in the situation where you have an employee that was at work and they have tested positive, they're infected. What do you do? Well, that's a really big question. But this is specifically talking about, well, how do you notify other employees and what information do you need to give them? So this law is tackling 3 types of notices that you need. This is tackling 3 different types of notices that you need to give to your employees that were at that work site with the other individual that was actually infected. Here's the big thing. These notices, these 3 notices, need to go out within 1 business day of you being notified of the infection. That is not a lot of time. And there is a good amount of information that goes into these notices. So like I said, when a client calls me with, hey, there was a COVID infection at the workplace, there are so many things that are going on in the employer's mind. This is probably not one of them. Like, oh, within 1 business day, I need to do this. So before we tackle this law, when we're talking about these notices, the advisable thing to do is to put these notices together now and have them ready to go, because it's a lot of work. It's 1 business day. So unless this happens on a Friday afternoon, you don't have a lot of time. So put it together now and just have it ready to go. So Murphy Austin did our model notices that we use. So when we're talking about what they look like, you know, I'm going to defer back to what my model notice looks like, but put it together now. So confirm, we asked. So there's a question just generally. Test results to confirm, we can't ask for test results. We can take their word. That's an odd question. I guess I want to know how the question arose, because usually how it happens is that an employee is telling you, hey, I tested positive. So they already give you that information. What you cannot require, and we'll get into this for the Cal OSHA regulations, is that if someone tests positive, you cannot require a negative test to bring them back into work. But that's coming up in our Cal OSHA regs. But getting back to AB 685. So what's the first notice? The first notice is it's written notice to all employees and to employees of contractors who were on the premises at the same time as the exposed individual that, hey, you were on the same work site as an exposed individual during their infectious period. And we will define that in the next slide. Now, for this particular notice, I have 2 versions of it. The first notice is, like, you know, Murphy Austin's, we're a law firm, so we have an office space, right? So we have 2 suites or 2 floors that we use here at Murphy Austin. So if I had an individual that was just, say, I had an infected person that was only on the 3rd floor, never went to the 8th floor. For at least for my 3rd floor people, if they were like in an area of the 3rd floor, the infected person was in an area of the 3rd floor where they only came into contact with like 1 other person. For all the other people, they're just getting a notice saying, hey, you were on the same premises as this individual when this person was in their infection period. That's model notice number 1. Model notice number 2 that I use is, okay, well, you were on the same premises as this individual, but you came into close contact with them. What's close contact? This is an important concept. A close contact is someone that was within 6 feet of an infected person during their infection period for 15 minutes or more collectively over the course of 24 hours. So not 15 minutes all at one time, but for 15 minutes over the course of 24 hours. Why I do that second notice is for those individuals, those close contacts, they need to be quarantined for 14 days. So my second, my version B of this notice, if you will, says, okay, well, you are a close contact with this person and you need to quarantine for 14 days. So it's a little bit different, but anyways, the first notice is just giving notice to your employees. The notice needs to be in a manner that you usually communicate with employees. So personal delivery, email, text message, however you do it. But the notice needs to be both in English and in a language that is understood by a majority of the employees. So if that's your sort of situation, you're going to want to have, at least you're always going to have an English version of it, but you may have to have another version of it as well, which is another reason why you may want to take why you may want to put these notices in place beforehand. So clarification, positive, this is going back to the prior question. Positive test result triggers coworker notice or symptomatic or illness. Well, if that's the case, I mean, you do have the ability under our, so the question is, it's clarifying the prior question, right? So it's laying out, I'm assuming, a hypothetical. Positive test result triggers a coworker notice or symptomatic or illness. So in that situation, could you ask for the employee's test results? In that situation, you would have that conversation, have you been tested? So you can ask for that. The EEOC, which is our federal EEO agency, allows you, if you have reasonable suspicion that someone is ill, it's very obvious, or they were sick, you can ask them some of these questions to clarify so you can determine what you need to do. I mean, one thing for these administrative agencies, at least when it comes to like symptoms and stuff like that, they do give you a good amount of flexibility. Okay, so continue on. Remember, for the first one, we were talking about an infection period. So what is an infection period? Well, it differs depending on whether or not you have symptoms or not. If an employee has symptoms, when's the infection period? When is it easily spread to other individuals? Well, that begins 2 days before they first develop symptoms, and it ends when 10 days have passed since symptoms first appeared, and at least 24 hours have passed with no fever, assuming that no fever-reducing medications were taken, and all other symptoms have improved. For an asymptomatic person, the infection period begins, presumably for this individual, that they actually had a test. It begins 2 days before the specimen for their positive test was taken, and it ends 10 days after the specimen for the test was taken. So what's important from this part is it's based on when did they go in for the test? It's not when they got their test results. It's when did they go in for the test, because that's when the specimen was taken. Now, I do want to note something here. As you can see, this is a very detailed, criteria, right? So you're going to need, if you find out that someone is infected, you're going to need to have a conversation with them, because you're going to need to know what the infection period is, because you're going to have to you're going to have to figure out who is a close contact. So you need to have these questions, this question and answer with the infected employee asking things like, well, did you get tested? When was the test taken? For those with symptoms, what were your symptoms? When did they first come on? And then, ultimately when you're determining whether or not they can come back, have things subsided. So you do need to have these conversations. The interesting thing that you get with all these laws and regulations is that when you're giving notice to other people that are in the workplace, you can't reveal the infected person's identity. It has to be confidential, which makes it really, really hard to determine, okay, well, who's a close contact? So how do you get that information? Well, according to our agencies, you get that information as to who is a close contact with the infected person by asking the infected person themselves, and using any other resources that are accessible to you. What you can't do, according to any of these agencies and the legislature, is send out an email and saying, hey, John or Jane Doe tested positive for COVID. This is when their infection period is. Let us know if you were in contact with that individual. Come talk to us about that. You can't do that. And the Department of Fair Employment and Housing has specifically said that violates medical confidentiality laws. So this is just one of those things where I have different laws and different agencies that are applying different laws, trying to all mesh together. But important note, but this kind of shows you the detail that you need to get. We continue on with AB 685. So that was our first notice. Now we're going on to our notice number 2. And the notice number 2 is it's going to be a notice to all employees and then contractor employees that you have on site who have been exposed with what are their COVID related benefits and options information that which they may be entitled to. So you're giving these individuals a notice that, hey, if for whatever reason you need it, here's things that can cover COVID in the workplace. So workers' comp, COVID-19 leave. So, you know, to the extent that we get family first extended or something along those lines, company leave. So mandated paid sick leave. These are options and things that are available to you. But importantly, this notice also has to have a statement that if you use any of these benefits, you're not going to be retaliated against and you're not going to be discriminated against because you use that. So it's an anti-retaliation and anti-discrimination statement. The third sort of notice that you need to provide to all employees is your disinfection and safety plan that you're going to implement, presumably pursuant to the federal CDC guidelines about, okay, you had an infected person in the workplace. What are you going to do to disinfect that area and to make sure that, you know, we don't have a potential for spread as to where that individual was. So those are your 3 notices that you need to provide to your employees within 1 business day of being notified that there is an infection. So not a lot of time, and as you can see, there's a lot of information in here that needs to be provided. And you can see how you can plan for this stuff right now. Like presumably your disinfection and safety plan is going to be the same throughout the entire process. Your benefits and your options are going to be the same. You can put this stuff together now. So that's what the diligent employer does. So other parts of AB 685 is it authorizes CalOSHA to act when it's an opinion. There's an exposure in the workplace and there's an imminent hazard. And we'll talk about this, but basically it allows CalOSHA to shut you down. And it makes it easier for CalOSHA to issue you serious citations. Next slide. So just going over a few of the other requirements from 685, it requires the state public health department to report some information regarding outbreaks, civil penalties. If the number of CalOSHA cases within a work site constitutes an outbreak, employers have 48 hours to notify the public health department and provide the number of cases at the workplace, employee names, occupations, and worksite information. So remember, under the other law, we were just talking about the workers' comp law, you needed to inform, if you had 5 or more employees, you need to inform your workers' comp carrier of 1 positive case. This is something different. If you have an outbreak, you have 40 hours to notify the public health department. Now, remember when I talked about the legislature and these agencies not talking to each other about these laws and we get somewhat inconsistent information? This and the law we just talked about is a classic example. Now, AB 685 and the workers' comp law we just talked about were passed by the same legislature. They were signed by the governor on the same exact day, but their definitions of what an outbreak is are different. If you remember in the prior slide, an outbreak was based on if you had more or less than 100 employees, right? Well, not the case here. What is an outbreak for this law? An outbreak for this law is the more standard, in my opinion, because it's the more common threshold that I see, where you have 3 or more COVID cases among employees within a 2-week period. So it's that 14-day period. So you'll see this with the CalOSHA regulations too, but just be mindful that one of the difficulties in all this stuff is that these folks are not talking to each other that are making these laws and making these regulations and making these guidelines, and it can be a problem. So that's why you need to think about this stuff in advance. Next slide. So once again, public information. CalOSHA under this law can do an order prohibiting use. That's basically shutting down your website or your job site. And it makes it easier for them to issue a serious violation in this sense. If CalOSHA is issuing a serious citation, they have to give you notice in advance and let you explain away the violation. My vendor talks when I've talked about CalOSHA. There's no point to this. CalOSHA never changes it once it's mine, but the legislature has alleviated the requirements. So it was a nominal requirement at best. Now they don't even need to do it, at least in these circumstances. Okay. All right, let's go home. Or at least I'm from CalOSHA emergency COVID regulations. regulations. So in years past, my story was when I was in law school for 2 years, I worked for the Cal OSHA Appeals Board. So if you ever get a citation that's coming from enforcement, that's called DOSH, the Division of Occupational Safety and Health. If you want to fight that and you want to appeal that citation, you appeal to the appeals board, which is where I worked at. So there's 2 levels there. There's the administrative law judges, those are like trial court, and then there's, oddly enough, what's called the appeals board. That's made up of 3 members that are appointed by the governor. That's kind of the Supreme Court of Cal OSHA. That's who I worked for. So I worked for them for a couple of years when I was in law school. I was not an attorney at the time, but I was in law school. I was their grad legal assistant. And because of that, I always consider this my home agency. I'm always interested in what they're doing, and no one ever seems to be interested, but now you have to be interested because they're huge this year. So I'm very mindful of what's going on here. I always have a couple, at least 2 or 3 Cal OSHA appeals going on at any given time, because there's not a lot of us that actually do Cal OSHA work in California. And that, the reason is because we all tend to be alumni from the Cal OSHA Appeals Board legal unit, and they only employ like 3 people at any given time, and they've been around since the 70s, so there's lots of us. So this is a big agency for me. I'm always interested in what's going on, and I'm definitely interested this year. So back in the spring, we got guidance, not regulations, saying that IIPP should have already be general, and they should already cover COVID. But hey, you can add this other specific section in here that's addressing COVID. And you also need to provide training. So, I created, for my clients, I created like a model IIPP amendment that just addressed COVID and training. What we have here are emergency regulations regarding COVID. This is not the same thing. These are entirely different. So if you haven't done anything to your safety or your IIPP plans, if you haven't done anything since the spring, or you haven't really done anything since November 30th, 2020, you probably need to do something under these regulations. So we have Cal OSHA emergency regulations. OSHA, both at the federal level and at the state level, were criticized immensely for not doing enough to protect worker safety as it pertains to COVID. And there was a request for emergency regulations a while back, and Cal OSHA didn't do anything with that. And then a few months later, it adopted these. So what are emergency regulations? Emergency regulations are regulations where basically they don't have to go through the regular public notice procedures, where the public has the ability to actually tell Cal OSHA why the regulations they're enacting are confusing or are problematic, or the public has any right to say any of that stuff. Basically, they get to do it behind closed doors for the most part. But emergency regulations are temporary to a certain extent. So the regulations we're going to talk about became effective on November 30th, 2020. They expire on October 2nd, 2021. So when people are asking, when are we going to open up and when are things going to get back to normal? At the very least, I know it's not going to be before October 2nd, 2021. Just based on these regulations and what they're requiring, unless we get these amendments. Now, the Cal OSHA emergency COVID regulations are a mess. They're 21 pages, they're single spaced. It took me, when they first came out, about 3 hours to go through them to at least have an idea as to what they were doing. When I created my model COVID plan that we're going to talk about here, that took a good 8 hours, I would think, to put that all together. Really complex stuff. Here's how baffling or how complicated and the issues of that complexity that's created. Within 1 week, the governor had to issue an executive order of these regulations being issued to clarify, because they were already outdated, because they're written in such a way that they're very rigid. So there's not a lot of flexibility. So within 1 week of being issued, the Fed, CDC came out with guidelines that now made the Cal OSHA regulations to a certain extent somewhat outdated, so they needed to be updated. You will also see on the Cal OSHA website, they have a Q&A section explaining these regulations. Now, in the past, when I do my appeals, Cal OSHA always says, well, if it's not a regulation, it doesn't really apply to us. So, they have policies and procedures that they need to follow when they come do an inspection of your work site. They oftentimes don't follow those. And they always say, well, it's not required of us. These aren't regulations. So, it's just kind of guidance. So I don't know how serious when they're issuing these citations and they're interpreting and applying these regulations that they're going to be. But what I know is that according to its question and answer period, they understand that these regulations are hard to comply with, and they are going to determine whether or not in assessing citations and penalties, what were the good faith efforts, and was there a good faith attempt by the employer to comply with these regulations? They have also said that prior to February 1st, they're not going to issue, they will issue citations, but they're not issuing monetary penalties unless it's just an egregious violation. I don't know if that was the case or not. I'm not privy to, I never heard of anyone that got cited so far, but at least that's what they're saying, is that they're going to look at good faith efforts. So let's dive into it. What did the 21 pages say? Well, here's the highlights of what the regulations do. The biggest part of the regulations is it requires employers to adopt a written COVID prevention program. This can be incorporated into your IIPP or as a separate document. I would never incorporate this into my IIPP. I created it as a separate document. Why, you might ask? Well, the reason is that if Cal OSHA ever comes out because you had like an injury or there was a complaint, they're always going to ask for your IIPP. So, that's fine. That's why I want to keep those documents broad. I don't like IIPPs being very long. I don't like them being very detailed, besides the bare necessities that the IIP regulation requires. Okay, so if this regulation gives me the option of keeping the prevention program separate, I'm going to keep it separate, because if Cal OSHA wants to see this separate document, they're going to have to ask for it, right? They're going to have to request for it. Whereas if they just ask for the IIPP, which they do every single time, now you're just giving them everything, right? So they can see, oftentimes what you'll see is employers get cited for IIPP violations when there isn't an underlying, like if it was an accident, there's not an accident violation, but hey, I noticed when I was looking at your IIPP, you had this problem. That's why I don't like that, like a heat and injury prevention plan inside an IIPP. I like it all being separate. So, but it does give you the option to the extent you do that. But I recommend the separate document myself. So that's the first thing. That's the biggest part. It's your program. The second thing is it talks to you about responding to COVID-19 outbreaks. So that's defined as an outbreak is a work site where there are 3 or more COVID cases within a 14-day period. Hey, that sounds familiar, just like the law we just did, AB 685, which it is. It's the same thing. But that's different than when an outbreak is under that workers' comp law, right? Because these people don't talk to each other. It also talks about how you respond to a major COVID outbreak, which is defined as 20 or more COVID cases in an exposed workplace within a 30-day period. And it also provides regulations on if you're an employer that provides transportation or you provide housing. So let's dive into the biggest part of the law, which is your prevention program. So these are just the topics that you have to hit on. When I created with my model program, it's about 11 pages single spaced. Now, Cal OSHA, if you haven't already gotten one of these things into place, Cal OSHA has posted on its website a model COVID prevention program. You can come up with it yourself going through the regulations. You could ask HR consultant. If you happen to know a good employment attorney, you could ask them too, because the good employment attorneys have already created model programs and they just need to plug in names and get it going from there. But here's what the program, these are just the elements, the overall requirements. System for communicating, identifying, evaluating COVID hazards, investigating and responding to COVID cases in the workplace, correction of hazards, training and instruction, physical distancing, face coverings, engineering controls, reporting, record keeping. Who do you exclude from the workplace when they have COVID or there's a COVID person in the workplace? And what is the return to work criteria? How long does a person actually need to be out? So this is just the overview. Like I said, for each one of these topics, there's like, depending on what it is, 10 to 20 subtopics you need to address. It's incredibly detailed. But one thing is, when you're putting together these plans and you're reading them, is that at least gives you some idea as to, okay, well, what's the field we're playing on? Like if someone was who's a close contact, right? Which we answered in another slide. Those are the folks that are within an infected period, person within 6 feet of them for 15 or minutes or more during a 24-hour period. So who's a close contact? How long do I keep someone out if they're infected with COVID but they don't have symptoms, or how long do I keep them out if they do have symptoms? It gives you a lot of that information. This is also the regulation that says that if someone is infected, you can't require a negative test to come back. So it gives you a lot of good information. But there are some very unique aspects to the prevention program. I should mention that these are very controversial. Like I said, they are confusing regulations. There are 2 lawsuits that are going on. One is in LA County and the other one is in San Francisco County, arguing that the regulations are illegal for a variety of reasons. One, that they shouldn't be emergency regulations. Like I said, Cal OSHA has the request for Cal OSHA to put these into place were months and months before it actually happened. And actually, in the internal documentation within the Cal OSHA system, there are documents from staff saying to their board, this is not an emergency regulation type system. We don't meet the requirements. So that information is being used against Cal OSHA, and they're subject to at least 2 lawsuits. So I would expect, I think the hearing on the injunction in San Francisco is this week. So hopefully we get some guidance here as to what's going on. We may have some injunctions coming down that's going to change the landscape. But for the time being, this is still good law, so you need to follow it. So here's one of the more controversial aspects of it. The COVID prevention program effectively creating a paid sick leave. So certain individuals need to be excluded from work under the regulations. Those are people that were close contact with infected individuals and people that actually have COVID. But the regulations say this: for employees that are excluded from work or otherwise able to work, employers shall continue to maintain or shall continue and maintain an employee's earnings, seniority, and all of their employee rights and benefits, including the employee's right to their former job status if the employee had not been removed from their job. Employers may use employer-provided employee sick leave benefits for this purpose and consider benefit payments from public sources in determining how to maintain earnings, rights, and benefits where permitted by law and not covered by workers' comp. What is that saying? It's saying that if you're excluding someone because of these regulations, because they were in close contact or they were infected under certain circumstances, because we'll talk about a few of the exceptions here, but for the most part, you need to pay them while they're out. Now, this is not Family First Corona Response Act. That expired at the end of December. This is different. And there's no tax credit attached to this. And this is one of the most controversial aspects of these regulations, because usually it's our labor commissioner that is regulating wage and hours, stuff like this. I am not aware of any other Cal OSHA regulation that has ever done this. So they're being attacked as saying, hey, Cal OSHA, you didn't have the authority to do this. But like I said, for the time being, this is still good law. Now there are exceptions. You know, the employee has to be able to work, if they're not able to work, and in the question and answer section of the Cal OSHA website, it says, okay, like if someone, because of their COVID symptoms, can't work, then they don't get this. Or, maybe someone's unable to work for a reason that's unrelated to protecting persons at the workplace. So that would be like, the employer needs to shut down their operations for whatever reason that might be, but it's not directly related to this employee having COVID. So if that situation, there are a few exceptions here, but this is one of the most controversial parts. So be mindful of this, that if you're excluding people because they're positive or they were a close contact, that you may need to pay them for that time. But you may see here that you can, employees can use paid sick leave benefits and public sources, public source benefits, things along those lines. But this is an example of agencies not talking to each other, because Cal OSHA is saying, well, you can require employees to use their paid sick leave, those 3 days or 24 hours. The labor commissioner has a different opinion about whether or not an employer can require that. But that's just two agencies not talking to each other or not understanding each other. So going on to the next slide. So the multiple COVID infections and outbreaks. So now we have gone on from your written plans. Now we're talking about multiple infections and outbreaks. This is just kind of highlights, but it kind of gives you a taste of what it's all about. It says employers shall provide COVID testing to exposed employees at no cost to employees during their working hours. Employees shall be tested and then tested again a week later if you just have an outbreak. Thereafter, employees must test employees on a weekly basis. You need to investigate and determine if workplace factors contributed to the outbreak. You need to determine whether or not you need to change your policies and lighten up an outbreak. And you need to notify your local public health department within 48 hours of learning of at least 3 cases. So I want to talk about the first thing. So there are certain parts of these regulations that say the employer shall provide COVID testing to certain types of employees, right? there's been lots of questions about what does that mean? Does that mean that the employer actually has to bring someone out to their job site to provide the testing? In the Q&A section of CalOSHA's website, they say the answer is no. You can send them somewhere. If there's a cost, you need to reimburse them for that cost. If it's free, you can provide that to them too. But CalOSHA brings up other unique things that you wouldn't expect from CalOSHA. It says if you're just sending someone off to some third party to get tested, you need to pay them for their travel time. You need to pay them for their time. You need to pay them for their mileage and do appropriate reimbursements if that's the case. So there, again, that's something I would expect from the Labor Commissioner, not from CalOSHA, but these are the things that they're saying. So just be mindful of that. You don't actually have to bring someone into your work site to do the swabs, to do the testing, but that's just how it's structured. So the question is, what if they were, there's a question for me, and it says, what if they were exposed not during work? So I'm assuming what the question is, going back to that prior slide, and we'll take a look at that real fast. Excuse me, that was next. So remember, there's certain people that you need to exclude from the work site, right? There is at the very bottom here for the employees that you excluded from work. So these are people that were infected, presumably not your close contacts, because your close contacts are probably going to be at work, but it's possible that a close contact happens outside. But if you look at the exceptions, it is written when the employer demonstrates that COVID-19 exposure is not work related. That's the second bullet point at the very end. So this is going to be very similar to one of the exceptions to the workers' comp law, the first law that we talked about. So once again, sometimes employees are very, very just upfront with you as to how they got exposed. So if that's the case, then they admit, hey, I was at a funeral and I hugged someone that was infected. Great for you. Otherwise, if you have some other objective evidence, that's what you would rely upon. The question is, who's going to enforce that requirement as far as being paid? CalOSHA has said that they'll just issue citations because citations have an abatement requirement. So that would be an interesting citation, right? We're going to cite you because you're not providing the COVID pay, and the abatement is provide the COVID pay. So that's going to go to a board that doesn't deal with wage. This is my board. Those ALJs, they did not. There was at one point during the Schwarzenegger administration, there was talk about having ALJs like administer and deal with other aspects outside of their one law. And they didn't want to do it because that was another expertise level, and they didn't want to get that. So we'll see what happens. Okay, going back, major COVID outbreaks. So remember, this is for those folks that where there's 20 within a 30-day period. For these folks, COVID testing twice a week, but very similar requirements: exclude COVID positive cases, investigate, do hazard correction, stuff like that. Notify your local health department. Okay. So I'm somewhat mindful of time here. So I'm going to go through this law very quickly. There was one other big thing that I wanted to talk about. Extended crime leave, so prior law, victims of serious crimes and domestic violence and stalking, sexual assault, they had certain crime leave entitlements. We got a new law that kind of consolidates all that stuff. So it provides victims of serious crimes with the same level of protections as victims for domestic violence. So as you can see, if you look at the back, kind of victims of domestic violence, they get time off to secure the health and safety of themselves. So, it just kind of consolidates that. This is not the big one that I want to talk about. So you'll excuse me if I go through it quickly. This is what I want to talk about. The California Family Rights Act. So in my opinion, there's three things that in California employment law that are really hard for employers to understand and for practitioners that do employment law, including me. So the number one most confusing law that we have in California for employment law is the prevailing wage law, which Scott talked about earlier. This is not that, but a lot of you folks deal with that, and you'll understand why that's so confusing. The number three thing is independent contractor status, which was not the case 3 years ago, but it is now. That is so confusing. I could teach independent contractor status in 10 minutes 4 years ago or 3 years ago. Now I need a full hour to 90 minutes to do it justice. But the second thing is this, the Family Medical Leave Act, but its California counterpart, the California Family Rights Act. Okay, so let's do a little bit of history here. Back in the Clinton administration, we got the Federal Family and Medical Leave Act, FMLA. that applied to employers with more than 50 employees. And generally what it said is for qualifying employees, they're going to get up to 12 weeks of job protected leave to deal with a serious health condition for themselves or to a close family member. California came in and they created their own counterpart law for the state. So very similar, and for the most part applied to employers with more than 50 employees. But there were certain provisions like baby bonding that applied to employees with employers with more than 20 employees. But for the most part, they were very similar laws. But here was the key, right? It was 50 employees. So that was the threshold. So for the most part, a lot of employers didn't have to deal with this, especially small employers. Well, what this law does is it's a huge expansion of that. So now the California Family Rights Act now covers small employers, which are 5 or more employees. So if you were under 49 employees, you probably really didn't deal with this unless you were in a baby bonding situation. Now you have to. And this is really complex and it's really unfortunate. This is such a hard law to comply with. But with some planning, you can tackle it. But again, it's about having just, getting your policies in place, having an idea as to what this law is and what's required of it. But one of the consequences of the law is that now CFRA, which is the California Family Rights Act, and FMLA, which were very similar at one point, are now very different laws. So let's talk about some of the changes. One big thing, of course, is that now CFRA applies to employers with more than 5 employees, and FMLA still just applies to employers with more than 50 employees. So who it applies to these two laws is the big difference. There's also things like there was a geographic restriction under FMLA. The employee has to work for at least 1,250 hours during a previous 12-month period within a 75-mile radius of, a work site with 50 or more employees. That's still the case for FMLA, but now for CFRA, it's just the 1,250 hours within the 12-month period qualifying factor. That 75-mile radius thing is not there in the state law. Here's the other big thing, and it's going to have a consequence. So under FMLA and CFRA up until this year, it was for 12 weeks of unpaid sick leave for yourself, for your children, parents, spouse, right? For a serious health condition for the most part. It has expanded that definition, CFRA. Now it applies to grandparents, grandchildren, domestic partners, and siblings. FMLA doesn't require that, only the state counterpart does. This is going to have a consequence in a few slides from now. Also, sometimes there was a situation where both parents of a child needed to take leave, and usually that they weren't allowed at the same time to take that leave. That's no longer a restriction under CFRA. There was also, an exception effectively where key employees, these are high-level executives, didn't have to get, these benefits that are coming from these laws. That no longer applies to CFRA. And then there's both of the laws to a certain extent apply to military activities, and then CFRA's just expanded it out. But let's go on. Okay, so what's new to CFRA aside from the stuff that we just talked about? Well, one is that if someone is going to request CFRA leave from you, or they make you known that they need it, the leave is not deemed to have been granted until the employer provides the employee of a guarantee of employment in the same or comparable position upon return when they come back from the leave. So what that means is if you're put on notice under CFRA, what those CFRA regulations require is all these notices that go out. This is why it's so complex. One of those notices needs to be if the employee is granted CFRA leave, they qualify for it, it's a qualifying reason to take it, there now needs to be a written guarantee that, hey, when you're done with the leave, you're going to come back to the same position or a comparable position. And if you don't, that 12-week clock doesn't start to run. That is entirely different from FMLA. FMLA had that same requirement in the regulatory scheme, but the Supreme Court knocked that down years ago. But now we have it here in the California counterpart, so that's a big change. Also, the employer must maintain and pay for the employee's coverage under a group health plan for the duration of the leave at the level and under the conditions coverage would have been provided if the employee had continued employment continuous for the duration of the leave. So effectively, whatever you were paying for the employee as far as their benefits, your portion at least stays the same. And you got to continue that on. That's a big difference. And it's a cost, right? Because otherwise the leave is unpaid. So let's talk about the problems. And this is why if you're an employer that has more than 50 employees, this is why you really need to pay attention. It is possible that you don't really have to pay, or you don't really have to provide 12 weeks, you have to provide 24 weeks, and I'll explain that. So under the prior version of CFRA, they were very similar, right? So if someone took CFRA leave, for a healthcare condition for themselves, that's the same thing as FMLA, right? So the laws ran concurrently. They both provided 12 weeks. So when they were done with the 12 weeks to care for themselves, both laws, they exhausted their benefits under both. But remember, now CFRA provides the entitlement to take leave for more individuals, family members, than FMLA does. So let's talk about that. So let's assume an employee needs to take 12 weeks of CFRA leave to care for their grandchild. Recall, a grandchild is not someone you can take leave for under FMLA, but you can under CFRA. Okay, under this scenario, let's assume they take all 12 weeks. Okay, the CFRA leave is exhausted, but they have not taken a minute of their FMLA leave because grandchildren aren't covered by FMLA. So let's assume the employee comes back from their CFRA leave after caring for their grandchild, and then they say, oh no, now I need family medical leave under FMLA for my own health condition. Well, remember, they haven't exhausted a single minute of FMLA leave when they're out for their grandchild. So assuming that the employee qualifies for FMLA leave for their own serious health condition, they can take that too. So altogether, how much is that? 24 weeks. We are uncertain as to how this is going to be resolved. But my hunch is it's not going to be in an employer's favors. And I think it's probably going to be a 24-week leave entitlement altogether, if all the stars align, of course. So as a practical matter, every employer under these regulations needs to have a CFRA policy in their handbook. So if you don't have that, you need to get that if you qualify. What I am now doing is when I'm modifying our handbooks for clients, I now have, if you are over 50 employees, I have a FMLA section, and I have a CFRA section because they are now so different. I used to combine them if you were an employer with more than 50 employees. I'm not doing that anymore. I'm separating them out. So moving on. Let's just go through this real fast. This is AB5 because I got 4 minutes left. AB5, you might remember, this effectively made independent contractor status almost impossible in California. We got this ABC test. So if you, unless someone could satisfy all 3 of these requirements, they're free from the control and direction of the hirer. They're performing work that is outside the usual course of the business of the hirer, and the individual is customarily engaged in independently established trade, occupation, or provision. Unless they could satisfy those 3 requirements, they were going to be an employee. But the law created all these exceptions, which is kind of a misnomer. What the exception meant is that, okay, if you fit into all these criteria, we're not gonna apply the ABC test to determine if you're an independent contractor. We're gonna apply this 1989 California Supreme Court decision called Borrello to determine if you're an employee or independent contractor. Now, Borrello is not a walk in the park either. It's still hard, but there's more flexibility. So we did get a little bit of action. I'll talk about it briefly. It just creates more statutory exemptions from the ABC test, saying, okay, for these folks, if you meet these tests, Borrello applies. Here's some of the industries: single engagement, business to business, referral agency, that sort of stuff. You can see where the lobbyists were definitely in play here: the music industry and performers, professional services. If you're a freelance writer, you got an exemption to possibly have Borrello apply. That's why, if you're in the situation, it might be significant just to determine, okay, how do I determine ultimately if someone's an independent contractor or not? But with that being said, we also had Proposition 22, which passed overwhelmingly. But this primarily applied to those individuals that were labeled as independent contractors that worked for like Lyft or Uber, one of those things. This was all about a specific industry putting up money to get an exemption for themselves. So for you contractors, that's not going to apply to you for the most part. Okay, with that being said, if you were interested when we were doing updates, this was our portal. We'll do updates as needed. Of course, Murphy Austin still does its monthly podcast. This podcast for this last month's podcast was all about the COVID emergency regulations. So anyways, there are resources that are out there. My recommendation to you, if you take anything away from this, from my portion, there's 2 things you need to, or possibly 3 things you need to do right now. 1, get your COVID Cal/OSHA prevention program in place now. 2, if you don't have a CFRA policy and you're covered by CFRA now, get it in your handbook. And then 3, do all of your model notices now. Just get ready. So with that being the case, excuse me, we are on to questions and answers for anyone. So there's no one that is up on the screen right now, so I'll give it a few minutes or a few seconds. Be better.
Thank you, Aaron, and thank you, gentlemen. Yes, everybody, please go ahead, send in any additional questions that you might have. This is the perfect time to do so. Okay, we do have a question. Do I need a COVID prevention plan if I updated my IIPP already?
Yes, you do. Like I said, the guidance for updates to the IIPP was in the spring. This is from the prevention program is from November. So if you haven't done anything Cal/OSHA related since November 30th, you probably have to.
Wonderful, thank you. And we do have a follow-up question to the question that was confirming whether to ask for test results or taking their word. And the question is, if an employee takes a COVID test and notifies the employer they tested negative, can we ask to have the actual test results?
I would recommend, I've got this question before, I would recommend not doing that. Otherwise, it becomes a medical document that you have to maintain for years and years and years. So unless, I mean, you can ask for symptoms and stuff like that, but no, I mean, if someone tells you that they tested negative, remember the big thing, the big confusing thing for certain employers is that they just assume that testing is the answer to everything. It's not. It really is not. Testing is it's not, at least up front, a huge part of this. It's about, okay, do you have symptoms? Were you close contact? It's the time frames that matter, not necessarily a positive or negative test. Because remember, the incubation period, it's changing, but depending on where it's at, right now, CDC is saying it's 7 to 10 days. So it's possible that someone was exposed to COVID yesterday, they test the next day and they test negative. But because that incubation period, it's possible on day 7, they test positive. So that's why you can't put all your eggs in one basket with testing.
Wonderful, thank you. Another question we have is, would you mention the horizon regarding vaccinations?
The horizon? I can't tell you. I'll tell you what, I'll make a tangent that I don't know exists off that question. So it's about, as far as vaccinations, where do I see that? The big issue, I think, for vaccinations is going to be whether or not you require them or not. So the EEOC gave us guidance about a month ago, and implicit in that, but it was somewhat clear in my mind, is that as an employer, you can require vaccinations. You can make it mandatory, but you have to have certain exceptions out there for like reasonable accommodations for disabilities or religious objections. When I did a model mandatory plan, I also have carve outs for things like, you know, you're pregnant or for some other reason, just come talk to us. So I've structured it in such a way as, okay, once a tier opens up and you can get vaccinated, you have such amount of time to get it done. So that's where I see the horizon with that issue, is whether or not employers are going to mandate that it happens.
Another question we have is if employers can require testing.
Yes, they can. You have to do it. You have to do it in a non-discriminatory way, so you need to do it for everyone. But yeah, we got that guidance from both the EEOC and its state counterpart, the Department of Fair Employment and Housing, a few months into the whole COVID crisis. So yeah, that is established. Again, that's up to you. There's a tremendous amount of cost there. And again, just because someone tests negative does not necessarily mean that they don't have COVID. So be mindful of that.
Thank you. All right. With the employee's approval, or if the employee would like the other employees to know, can you release their name to other employees? I'm assuming if they tested positive.
I'm assuming that this is a testing positive. I suppose if they want to do that, You know, the objections are confidentiality, but if the employee, you know, it's the same thing with like, you know, an employee comes in and, you know, they were diagnosed with cancer. As an employer, you can't tell people that for the most part. But if the employee is volunteering that information, that's fine. So I haven't seen that posed in any administrative guidance on that, but I don't think that that would be a problem. But if they're giving you permission to make those communications, make sure you have that right.
Okay, another question we have is, do some counties require notification to public health for each individual case? For instance, Sacramento County.
I'm not aware of what all 58 counties require, but I don't believe Sacramento. So I know Sacramento because that's just where I'm based for the most part. So can you read that for me one more time? What they're requiring?
Absolutely. Do some counties require notification to public health for each individual case?
Yeah, I'm not aware of that, of each individual case. I'm just aware of for the law for the 3 cases. And that was also the guidance that was coming from the California Department of Public Health. I can't speak to all 58 counties, but I'm telling you, I'm just not aware of any.
Okay,
Check
great.
your county order.
Another question that I have is, can I tell employees if someone they work with is infected with COVID?
Can I tell employees that someone, well, again, you can't reveal an employee's identity about that. What you can only reveal is that's going back to AB 685. You can reveal that they were working with someone that tested positive, but you cannot provide a name for that. And that's good. Trust me, I understand how difficult that is. But that's what all the agencies and the legislature has said that you can do. You have to notify them that they were on the same premises if this, you know, if the non-infected employee, presumably non-infected employee was there during the infection period. But you can't tell them, hey, it was this coworker that tested positive. Remember, you need to get the information about close contacts from the actual infected person.
Great. All right, so we have one last question that has come through. So any and all, please go ahead, send in your questions. The remaining one that I have is, what if someone can't return to work when their CFRA leave is over?
Okay. Well, California. Okay, so this is California Family Rights Act. So you get 12 weeks of unpaid leave, right? So the question is, what happens? The 12 weeks are up and the employee's still sick. They can't come to work. Well, if you have more than 5 employees, that doesn't necessarily mean it's an automatic termination. What you need to do is you need to determine whether or not you need to provide additional leave as a reasonable accommodation under the ADA. And a lot of times the answer to that is yes. So it's a hard situation to be in, but just the point is when someone is done with the 12 weeks, that is not an automatic, you are good to fire and there's no consequences. There may very well be because another law comes into play.
Great. We have 2 other questions that came through. The first one is regarding AB 685, the notice of benefits option. It says we must provide to all employees who have been exposed. Can you recap the definition of exposed?
Yeah, well, what I'm doing is I'm just exposed is basically anyone that was on the premises. So I'm doing that expansively. So when I do the model notices, to be quite honest with you, even though they're 3 individual notices, I am doing it's actually one just big document that I'm doing for all 3 of them.
Okay.
I mean, to be quite honest with you, there's that's an expansive look at that term. There's nothing adverse. I mean, these are all things that presumably the employee should know about anyways. You know, basically it's saying is, hey, you have these benefits available to you, which presumably they could see in your handbook. You know, you're not going to be discriminated against if you use them.
Okay. I heard the Oregon OSHA mandated a COVID officer. Do you have an opinion about whether California will follow suit?
Well, I mean, we have 3 different sections to our Cal OSHA. We have the standards board, they come up with the regulations. We have the appeals board, they determine appeals, and we have enforcement. And enforcement has a chief. So, you know, the chief is the one that's in charge of all things Cal OSHA related. Whether or not they appoint someone specific to that, I have no idea. I haven't seen or read anything, and I get a lot of industry stuff on that. So I don't know. Maybe they end up doing it for political purposes, but I don't know how that would really change things as far as enforcement.
Wonderful, thank you. So that was the last question that, that has come through. I'll give maybe a few more seconds for folks to send in any last questions. And it looks like we don't have anything, but fear not, if you do have questions that pop up after the webinar happens, we all have that driving, oh man, I forgot to ask this. Go ahead, send us an email. We'll be still happy to help. We'll reach out to you. But thank you, gentlemen, from Murphy Austin. Thank you so much for sharing with us today. And yes, we did get a question about the slide. We will be sending out the slide decks. We will be sending out the recording from this. We appreciate all of you guys for taking times out of your busy schedules to join us for today's Bender U covering construction and employment law updates for 2021. So yes, we will be sending all of this out following, once the webinar is wrapped up, you'll receive the link as well as the PDF for your convenience of the slide deck. But again, any questions that arise after our webinar has concluded, please feel free to reach out and we'll be happy to help. So thank you again, and we hope you all have a wonderful day.